Welcome to Complex Conversations. In this podcast, we hope to make complex living simple by explaining the law related to sectional title schemes, homeowners associations, and other types of community schemes in South Africa. I'm Jennifer Paddock, a dual qualified lawyer and director here at Paddock's, a specialist community schemes law and training firm. Now, in this fifth episode, I'm going to be discussing the rights of owners in sectional title schemes. This was actually a topic that was requested by somebody who has been listening to the podcast. Thank you to everybody who's been emailing me with your feedback. I really appreciate it. And I'm so glad this podcast is helping you to learn more about sectional titles. And the request that I got was actually to do an episode on owner rights and responsibilities. But this is such a huge topic that I decided to break it up into two. So in this episode, I'll do owner's rights, and I'll do another episode later on owner responsibilities and sectional titles. So in this episode, I'm going to unpack for you a body corporate's organs of government so you can see where owners fit into the picture. We're going to look at some general rights of a sectional title owner in relation to their property. We'll look at owner rights in relation to the trustees, owner rights in relation to the body corporate's finances, owner rights in relation to meetings, owner rights in relation to accessing the body corporate's records and documents, their rights to appoint and terminate managing agents, and the rights of owners in new developments. So let's start with a body corporate's organs of government. Now, this might sound like a bit of a strange concept, but a body corporate is not a living thing, and so it can't make its own decisions. It's a legal entity. It needs real people to make decisions. And in a body corporate, you have effectively two main organs of government. You have the owners, who are the members of the body corporate, and you have the trustees, who are the elected executive of the body corporate, or the representatives of all the owners. The owners, in general meeting or in writing, take decisions by ordinary, special, or unanimous resolution. And the trustees take decisions in writing or at meetings by trustee resolution. The body corporate members, who are the principal organ of government, are actually the ones who are in control, in that they are able to direct and restrict the actions of the trustees. So while the trustees are the ones who are carrying out the day-to-day running of the scheme, and they seem to be making all the decisions, the owners actually have an opportunity to direct or restrict the trustees' actions through Section 7.1 of the STSM Act, the Sectional Title Schemes Management Act, which says the functions and powers of the body corporate must, subject to the provisions of this Act, the rules and any restriction imposed or direction given at a general meeting of the owners of sections, be performed and exercised by the trustees of the body corporate holding office in terms of the rules. So I want to give you a few examples of directions and restrictions that owners can impose on trustees, either at an annual general meeting or at any general meeting. They can impose financial restrictions. So owners can restrict the trustees from spending more than a specified amount on a particular item without the agreement of owners at a general meeting. And this is to ensure that large amounts of the body corporate's money are not spent without proper oversight and agreement from the owners. The owners can also impose maintenance directions. They can direct the trustees to prioritize certain maintenance tasks over others. The owners can also impose hiring restrictions on the trustees. So they can restrict the hiring of certain service providers. They can restrict the trustees from hiring a specific service provider due to past unsatisfactory service, for example. They can also impose meeting directions on the trustees. So owners can direct the trustees on how, when, and where to call meetings. And this ensures that the meetings are held in a manner and at a time that is convenient to the majority of owners. They can also impose rule enforcement directions. So owners can direct the trustees to enforce certain rules more strictly. For example, if there's an ongoing issue with noise disturbances, the owners can direct the trustees to take stricter action against those causing the disturbances. So there's just a few examples of how the owners in general meeting can direct and restrict the actions of the trustees. So let's move on to the general rights of owners in relation to their property. So sectional owners have the right to use all areas of the common property that are not subject to exclusive use rights. Section 2C of the Sectional Titles Act says that owners of sections own the common property in undivided shares. What this means is effectively that every owner owns every part of the common property in undivided shares. So you can't say, okay, I own this many square meters and my neighbor owns that many square meters of the common property. In effect, every single section owner owns every single brick, owns every single plant, owns every single part of the fence, but they own it in undivided shares. So in accordance with the PQ allocated to the section, that will be the proportion or the share that they own. But if a part of the common property is not subject to exclusive use rights, then every owner is entitled to have reasonable use and enjoyment of that part of the common property. So owners also have the right to peaceful enjoyment of their section and to not be unreasonably disturbed in their section or on the common property. And that's prescribed conduct rule 7. They also have the right to have their section supported by all other sections and the common property that is capable of giving their section support. That's section 28 of the Sectional Titles Act. Owners also have the right not to be unlawfully deprived of their property rights. And this is under the Constitution, section 25. And this includes the right not to have their electricity disconnected. That's called spoliation. And often in sectional title schemes, you hear when an owner of a section is in arrears, the trustees might threaten to turn off the electricity to that particular section to kind of use leverage and motivate that section owner to pay. They're not allowed to do that. So very, very important that we can't unlawfully deprive people of their property. Okay, rights in relation to the trustees. So apart from the right to impose directions and restrictions on the trustees, which we've discussed, the owners control who is elected onto the Board of Trustees. So they have the right to nominate any person for the office of trustee, and that's prescribed management rule 7.1, and they can nominate themselves, provided that they are not disqualified from holding office under prescribed management rule 6. So any person, they can nominate anybody, doesn't have to be an owner, doesn't have to be a spouse of an owner, and they can nominate themselves as well, provided that whoever they nominate is not disqualified from holding office, because otherwise, even though that person could in effect be elected, they would automatically be disqualified from office. So it doesn't make any sense to appoint somebody who can't actually hold that office. The owners can remove a trustee or chairperson by ordinary resolution at a general meeting, provided that the intention to vote on the removal was specified in the notice convening the meeting, and that's prescribed management rule 6G. They also have the right to direct the trustees by ordinary resolution to install separate water, gas, or electricity meters. That's prescribed management rule 29.3. And they have the right to request notice of trustee meetings. And if they do so in writing, they have the right to receive notice of all trustee meetings. That's prescribed management rule 11.4. In this case, they're also entitled to be sent the minutes of the trustee meetings within 7 days of the date of the trustee meeting. And that's prescribed management rule 9.2. Owners also have the right to attend trustee meetings and to speak but not vote at these meetings, except when the trustees resolve that their presence would unreasonably interfere with the body corporate's interest or any person's privacy. And that's prescribed management rule 11.3. All right, let's talk about owners' rights in relation to the finances of the body corporate. Now, the owners have a say in determining their levies. I think owners often think that they have no influence over the quantum of their levies, but they really do, because the owners are the ones at the annual general meeting who approve the body corporate's proposed budgets. And this is in terms of prescribed management rule 17.6J4. And it is these budgets upon which the owners' levies are based. So the owners also approve the maintenance, repair, and replacement plan on which the reserve fund is based. And they may lay down conditions for the payment of money from the reserve fund. And that's prescribed management rule 22.3. So if you as an owner are unhappy with the amount of your levies, you think they're too high, or you're not satisfied for some reason, you need to go to the AGM, you need to look at the proposed budgets, and you need to make suggested amendments so that when the budget is approved, you're happy with the budget in general, and then the levies that are going to be raised based on those budgets. All right, owners also have the right not to have body corporate funds spent except in accordance with the approved budgets. And that's prescribed management rule 9C. And this is subject to some exceptions which apply in the case of emergencies. An owner has the right not to have any unauthorized amounts added to their account, and that's prescribed management rule 25.5. An owner has the right to receive details of the levies due and payable by them annually or whenever there is a change in levy. That's section 3.5 of the STSM Act. And they have the right to written notice of their levies, the due dates for payment, and the interest applicable to late payments within 14 days after the approval of the budgets at each AGM. And that's prescribed management rule 25.1. An owner is also entitled to receive a final notice if any amount due by them is not paid before the body corporate takes action or debt recovery action against them. And that's prescribed management rule 25.2. An owner has the right on written request to a full and detailed account of all amounts debited and credited to their account with the body corporate. That's prescribed management rule 25.7. And an owner can require that the insurance replacement value of their unit or exclusive use area be increased. And that's prescribed management rule 23.1b. Let's look at owners' rights in relation to general meetings. They have the right to have an annual general meeting every year within 4 months of the end of the body corporate's financial year. That's Prescribed Management Rule 17.1. They also have the right to receive minutes of all general meetings not later than 7 days after the date of the meeting, and that's Prescribed Management Rule 9E. Owners holding 25% of the participation quotas can call a general meeting to consider and vote on one or more motions, which must be included without amendment in the agenda of the meeting. And if the trustees fail to call the meeting within 14 days of the request, the owners are entitled to call the meeting themselves. And that's Prescribed Management Rules 17.4 and 5. They also have the right to request a general meeting to consider and vote on any proposed reasonably necessary improvements to the common property, and that's Prescribed Management Rule 29.2. They have the right to appoint a proxy to represent them at general meetings, and that's Section 6.5 of the STSM Act. Let's look at owners' rights in relation to accessing body corporate records and documents. An owner is entitled to inspect and copy all of the body corporate's books of account and financial records. That's under Prescribed Management Rule 26.2. An owner is entitled to inspect all other body corporate records and documents, which are mentioned in Prescribed Management Rule 27, and the list is too long for me to detail in this podcast. But this list of documents does include owner contact details, but this is subject to the POPI Act, Protection of Personal Information Act, and that is a whole nother episode in itself, which I will do. And the body corporate must comply with an owner's request to inspect within 10 days, or in the case of inspecting the body corporate's rules, within 5 days. And that's Prescribed Management Rule 27.5. An owner is entitled to be given the names and addresses of the trustees, and that's under Section 3.1N of the STSM Act. And an owner is entitled to be given a copy of the body corporate's insurance policy and the receipt for the last premium paid by the body corporate in respect of it. And that's Section 3.1S of the STSM Act. Let's look at rights in relation to the appointment and termination of managing agents. Owners can appoint an executive managing agent if authorized by special resolution. That's Prescribed Management Rule 28.1. Owners holding 25% of the PQs can apply to the CSOS for the appointment of an executive managing agent, and that's under Prescribed Management Rule 28.2. Owners can, by ordinary resolution, appoint a conventional managing agent, Prescribed Management Rule 28.5. Owners have the right not to have a management agreement last more than 3 years under Prescribed Management Rule 28.7, although managing agency agreements can be renewed. Owners can cancel a management agreement before it expires on 2 months' notice if authorized by special resolution, and that's Prescribed Management Rule 28.7. And owners can, by ordinary resolution, cancel a management agreement in accordance with its terms or refuse to renew it when it expires in terms of 28.8. Finally, let's look at the rights of owners in new developments. So owners have the right to have a body corporate's first general meeting called within 60 days of the body corporate's establishment. The body corporate is established when the first unit is transferred to somebody other than the developer, and that's Section 2.8 of the STSM Act. And all the agenda items set out in Prescribed Management Rule 16.2 must be dealt with at that first general meeting. If the developer fails to call the first general meeting within 60 days, any owner has the right to call that meeting and recover the costs reasonably incurred in doing so from the developer. And that's Prescribed Management Rule 16.6. Now, I've gone through quite a lot there. There may be more rights. I'm sure there are. I haven't gone into all the decisions that can be made by unanimous resolution, etc., because it's just too extensive. But those are some basic rights that owners have in sectional title schemes. And I hope that it's shown you that owners actually have quite a lot of power if they know how to use it. So if an owner's rights are being violated, they can approach the CSOS for relief, provided that the relief they are seeking is covered by one of the orders a CSOS adjudicator is entitled to award under Section 39 of the CSOS Act. Now, I hope that's been helpful. We dive into all of this and much more in our sectional title schemes management course, which we run a number of times a year. We've got one coming up shortly. If you are interested in finding out more detail about that, please visit courses.paddocks.co.za. And once again, if you have any questions or if you want to suggest topics for future episodes, please email me, Jennifer@paddocks.co.za.